All right, so I think we should start. A very good morning to everyone, to Siddharth sir and to everyone who has joined for this webinar. Firstly, on behalf of PAC, I welcome all of you, and we are very grateful that all of you showed such great enthusiasm for this lecture series. To start with the session, introducing our speaker, introducing our mentor, Mr. Siddharth Marwah, who's currently a principal associate at Khaitan & Co. Sir is a 2015 pass out of Campus Law Center itself. And during Sir's time in Campus Law Center, the sheer participation that he undertook in Campus Law Center could be got from the fact that he served as the vice president of the Students' Union. And he's also currently the treasurer of the CLC Alumni Association, which I believe has done some wonderful work during the COVID times in supporting students of Campus Law Center. Before joining Khaitan & Co, Sir has worked with Amarchand Mangaldas and also Indus Law. As a student itself, his hard work was quite prominent when he was interning with creme de la creme firms like Trilegal. And Sir has gone on to attain a great level of mastery when it comes to mergers and acquisition, the whole sphere of mergers and acquisition. And I do not believe that there could have been anyone better to introduce us to this particular field of law. For third years, I believe it will be extremely important because we are in the process of deciding the field that we want to work on once graduating. So this would be a good primer for all of us to get a background, to get an insight into what constitutes mergers and acquisitions in India. For my first years, you will be reading some of the most engaging and interesting legislations in your third and fourth semester, company law, competition law, which you will get a brief overview here because all of them are very important.
Is it only for me, or I think Arushi's screen is stuck?
So maybe there is some issue with Arushi's network.
Okay, no worries.
I request you just wait for a couple of minutes. I'm
Yeah,
just
no
getting
worries.
back to her.
Yeah, take it.
Also, thank you so much, sir, for coming back to the campus and
It's always a
with this
pleasure.
idea.
Thank
Because
you so much for having me, and thanks to everybody for joining on a holiday morning. It's a national holiday. Everybody's joined in the morning.
Right.
yes, sir, Arushi is back.
I'm so sorry, electricity power cuts. However, my only request is to make the session as interactive as possible. Ask Sir as many questions as possible. I am assuming that Sir will be thrilled to answer them.
Yes.
So he is with us for 2 days. Get all your doubts cleared into whatever doubts you have regarding the law, regarding the practice, regarding how to streamline yourself into this field. And we are hoping to have a very rewarding and enriching session. Sir, I would pass on the mic to you now and to start with the session.
No, thank you so much, Arushi and Mayank, for your kind words. And thank you, everybody. Good morning. Thank you for joining in the morning. The idea is that, when we deciding about having this lecture series, the idea was that everybody who's in Campus Law Center, I know when I've been in CLC, we get a lot of exposure to litigation and how to go about it. And, when everybody joins the legal profession, there is a particular idea about the type of law you're going to practice, So, and mostly the type of exposure which we get, at least in my time, which you were getting in CLC, was towards the litigation side. But now over the years, a lot of our alumni, a lot of people have started venturing into the corporate law side as well. And they've started joining law firms. They want to make a career in corporate law. So, and during this course of this series, the idea is that we give you a brief of what is corporate law. What it is that we as corporate lawyers do. So, what is that we are doing? How is it that the work that we are doing is going to, progress? I will be very happy to answer any queries that you have in relation to corporate law, law firms, how to get through them, etc., etc. Those general questions, I would, love to answer all of them. The idea of this series is to give you a brief of what are mergers and acquisitions in India. What is the regime of mergers and acquisitions in India? So, these are terms which we hear a lot. You keep on reading that, A company has acquired B company. So recently you would have read that, Z and Sony are merging together. So a lot of these words, we keep on reading about acquisitions happening. You would hear a news article or read a news article that say Byju's acquired Akash at a certain amount, or a lot of these companies or a lot of these startups, they keep on getting acquired by bigger companies. A lot of companies keep on getting merged with each other. So what is the process behind it? So what is the law behind it, and what is the process behind it, and what is it that we lawyers bring to the table when it comes to all of this? Because a lot of these things, they appear to be very commercial when you see to it, right? So you were buying a company or you're doing something. So all of these things end up being very commercial. But what is the legal aspect of it, and what is it that we lawyers bring to the table? So I will also just project, I have a presentation prepared. Although I've shared, so Arushi, I've shared the presentation with the pack email as well. If you can
Right.
project it from there.
Right. So we'll just, Sanya, if you're logged in from the placement ID, could you just screen share that presentation? We can take down this particular one.
Sure, I'll just get it.
Yeah, it'll just be easier for people to navigate through the entire process. Have we gotten the final year results for this semester till now, or no, we're waiting for it?
So for the graduating batch of 2021, we have, and so I think all the results still are here. That's basically the ones that are going in third year are there. The first years are yet to have their second sem exams.
Okay. Yeah, I heard somewhere that it'll happen in the first week of October or something like that.
Yeah. So they're in a bit of in a middle state that is there. So hopefully they'll be done by mid-October, we are assuming.
Understood.
Sanya, you can take somebody's help also. Jashatru, if you can help with coordinating the presentation.
Otherwise, wait, do I have access of sharing it? Okay, somebody is presenting. Fine, perfect. Yeah, we can move on to the next slide. So what is M&A? Now, M&A in itself, so you see mergers and acquisitions. So there are two aspects to it. There is a merger and there is an acquisition. And both of them are distinct with each other. Now, a merger, as the word goes, is basically the coming together of two or more entities and combining and actually forming one business. So in India, how it works is that we have a proper merger regime, which is a court-approved merger regime, which is there in India. So your Companies Act under sections 230 to 234, it deals with what is a merger and how a merger process is done in India. So how it technically works is that two companies which want to come together, they form a merger scheme. The idea is that as a culmination of this merger process, you will have one entity in place. Now, why do companies do for mergers? You go for mergers because you want economies of scale. There are different types of mergers. There is a horizontal merger, there can be a vertical merger, etc., etc. A horizontal merger will be when two competing companies, they come together, say, and at the same level of business. Say, like you would have read right now, like a Z and a Sony, they're merging together. So that is what you call a horizontal merger, when two competing companies are coming together, merging to form one entity. You do this because A, it helps you with economies of scale. It gives you a bigger war chest to fight. It helps you consolidate all your clients, all your customers, streamline your processes. So it helps you get a bigger market. So a lot of people go for these horizontal mergers. There is a different type of merger. And again, these are not defined terms anywhere. So these are just colloquial terms and normal day-to-day usage words that we use. Then there is something called a vertical merger. A vertical merger will be that if today I am in an automobile manufacturing industry and we are manufacturing automobiles and my company, and then there is another company which is, say, producing the raw materials for this business. So what we do is that if we end up merging these two companies, that one business which we'll have will help us, because then we are making the raw materials in-house, and at the same time we have the production manufacturing with us as well. So sometimes companies go, keeping that in mind, they go for a vertical merger. There is something called a co-generic merger as well. And a co-generic merger is specifically when two companies which are in the same field or same industry decide that we want to merge and form one company. Now, this can be, say, if you're in the FMCG industry, in food manufacturing, and so my company makes biscuits, you have a company which is making, say, cakes, or if manufacturing, I don't know, tea leaves or something of that sort in the same industry. So you have the same supply channels, you have the same distribution channels. So you decide that why not, let's combine our two companies. It's in the same field as it is. And then both of us can use our own distribution channels and our own supply chain to make sure that we increase our sales. And plus we get increased budgets. So sometimes people go in that sense as well. Then obviously there is something called a conglomerate merger, in which you're a big business house. You as it is have a lot of businesses and different types of businesses which your company is undertaking. And then you go and pick up another diversified business and merge it with your company. So there are different types of mergers which are there, and different reasons why companies prefer to go for a merger. Now, picking up where I left, in India, whether when you comes to a merger, the merger regime is basically code-driven process under the Companies Act. Two companies which want to merge together, they'll firstly be required to file a merger scheme with the NCLT, which sets out the details and the various parameters of how that merger is supposed to take place. Then after that, what happens is that the court tells you, and obviously as this course progresses, we'll discuss all the laws involved and everything in great detail. The idea right now, and I think just to take a step back, how we structured this entire lecture series is into 4 lectures. The first lecture which we are having right now is to give you a basic idea about the entire merger regime, the different types of mergers which are there, the different type of acquisitions which are there, the documents which we use for all of this, to basically run you through a deal cycle from negotiation to due diligence, to give you an idea about what all it entails in a merger process. So this is more of an introductory lecture to just give you an outline, a brief outline about what all you're going to study and what all you're going to, we're going to discuss over the next 3 lectures, give you a basic outline of the entire process. Then after the introductory lecture, what we have is that we delve into the law. So the next 2 hours after that, we'll be discussing the laws involved, and the Companies Act, the Income Tax Act, the Competition Act, and the key provisions of these acts and how we use them as part of our merger and acquisition regime. And what are the important. So it won't be a very verbose thing where we are going clause by clause, but just to give you an idea of what are the important provisions that you should be aware of. So say tomorrow, even if you're going for an interview and you go for an interview at a law firm and they ask you some, abstract questions or something, you should at least know what all you would have read or what all you should have read. So that also gives you an idea. So then it's basically doing the legal regime. Then what we will proceed after that is that we will study about what is the due diligence process. In any law firm, when you will be going as an intern or as an A0, just as a fresher, a lot of work which people will make you do is to do a legal due diligence. Now, what is a legal due diligence? A legal due diligence is nothing but it's a mere investigation exercise. So if today I want to buy another company, or if I want to buy the assets of another company, I would want to know what am I buying? Because on paper, everything sounds good. You were telling me, oh, you're a very big company, everything's hunky-dory, there's no problem, etc., etc. On paper, everything is looking fine. But this company has been running for 20 years. Now, in the past 20 years, there may be a lot of non-compliances which the company has done. Some knowingly, some unknowingly. There may be some lapses, as part of the legal process which the company has not followed. As a result of which, if I end up buying the company, I will be liable to that penalty. There may be some ongoing litigations against that company. It's possible that somebody in some court in India has filed a, say, 100 crore case against this company or something of that sort, which has not been brought to my notice. So I will have my legal team conduct a legal due diligence in which they will check that has this company followed all the legal provisions? Has the company been run as per law? And what are the non-compliances? And then looking at the quantum of the non-compliances, if something can be remedied, well and good. If something cannot be remedied, then I take a business risk. So if my lawyers come and tell me that, okay, so this company, it's been carrying out exports, with these countries, which is not allowed, or this company has been doing this particular kind of business and has been raising foreign capital, but under the Indian law, if you have raised foreign investment, you cannot carry out this particular type of business. So this is a breach, and tomorrow if the RBI comes after you, you can have a hefty penalty of up to, say, 30 crores. So then it's up to me to see that, okay, if the deal size is that if I'm buying this company for 3,000 crores, then maybe 30 crores is not that big an amount for me, and I can take that risk because what I see, the advantages that I'm seeing are much more. So then it obviously comes down to business risks that I'm taking. But as lawyers, and we as lawyers, what our work is to project a picture to the client, to tell them what exactly is. So then we will discuss what a legal due diligence is, what is the due diligence process, how to conduct it, what all do you look at in a company when you're conducting a due diligence. Because it's not like you're doing an audit. You don't have to look at each and everything, and it's not even possible to look at each and everything. So what are the basic things that you need to look at due diligence process? And then lastly, how to draft a contract. So you have your share purchase agreement, you have your asset purchase agreements, you have a business transfer agreements, and all these other fancy words which you hear when you are talking about any corporate transaction. But what is it? So we will just discuss a brief outline of what all are the prominent clauses and provisions which these contracts have and how to go about them. So the idea is that by the end of this 8-hour lecture series that we're going to have, you have a basic idea about everything that is there, so that tomorrow if you are sitting for an interview or you are going for an internship, and you are sitting and when somebody asks you these questions, you're not blank about it. You know what is there. Ultimately, what will happen is that, like anything and like any aspect of law, everything you learn is based out of practice. As and when you start working, you just need to have that confidence in yourself. But it's when you start working, and as and when you start working, so obviously you pick up a lot of work as you go along. Not all of it is taught to us when we're studying in college. It's very different in how it runs practically. So the idea today is to give you a practical idea about how things work and what are the practical things which you need to look at from an M&A perspective, and because that is what you will be expected to do as a corporate lawyer if at all you tomorrow decide that this is the path you want to take. Now coming back, so this court approved process that I was talking about. So now when two companies, they want to merge together, they file an application, they make an application, and then they file it with the NCLT. So now that application will set out the various parameters of the merger, who is getting how many shares, what is the consideration at which the merger is taking place, etc., etc. Then the court asks the company to hold a creditor meeting and a shareholder meeting. Now, obviously, if you have creditors in the company, anything that you're doing, we will have to take their consent, because obviously they owe you money. They should be fine with the idea that your merger scheme deals with how their money is going to be repaid to them, or if the company you're merging with has enough funds that tomorrow if you merge with them, the company will have enough money to pay you back. So you obviously the creditor, so you need 3/4 of the creditor approval, and you need 3/4, so that's a little more than 75% of your shareholders to approve the merger scheme. And then once the scheme is approved by the shareholders and the creditors, then the court also ultimately ends up approving the merger scheme. And once the merger scheme is approved, you can go ahead with the merger. Mostly in mergers, they're cashless mergers which happen. There's no monetary transaction which takes place. Ultimately, what we do is that we provide shares in the merged company to the shareholders of the merging company. So say if B is merging with A, then ultimately you will only have one entity in place, that is the company A. So the shareholders of company B will be provided shares in the of company A. So that way, in the ultimate shareholding of company A, they will also be shareholders. So instead of giving them money, they are provided with shares. It's instead of in lieu of cash, you get shares of that company. So that's mostly how that merger regime will work. Now that is the merger aspect of it. Now, before going back, an acquisition, on the other hand, is when you end up buying either the shares of a company or the assets of the company, all our assets. So it may be possible that I may just want to buy that company, but I don't want to merge it with my own company. I want to run it as a separate company. Now I can do that because I really like the business of that company, and I think that's a very clean and nice company which is in place. So either I can buy out the entire company, in which case I'll pay the money to the shareholders of the company, and those shareholders of that company will sell the shares of that company to me. Correct. Now, I have not gone into the basic detail of what a share is, and I can do that for the benefit of the first year people. So in a company, the ownership of a company, if I'm to say that I own a part of the company, that ownership is part of these units which are there, which are called shares. So say if a company has 100 shares and I own 1% of that company, so I will be given 1 share of that company. Correct. Similarly, if I was to own 10% of that company and that company only has 100 shares, I would be given 10 shares of that company. So accordingly, if I want to buy out that company, I will have to buy the shares of the company from the shareholders, the people who are holding those shares. So, and then I make the payment to those shareholders and end up buying the shares of that company. So that's an acquisition which takes place. Now, sometimes it may be possible that I don't want to buy the entire company because say that company actually has been running for 20, 30 years and I don't know what all is there in that company, what all hidden costs are there. I don't know if there are any disputes which that company has with people, and it's not, so I don't have that kind of an idea. But I really like your business which is there. I really like the fact that you have 2 factories, which I recently did. So I did a deal with somebody and that company had the same problem. The promoters, what they thought were very shady people who had a lot of different cases going against them, and they had different problems which were happening. So that company did not want to buy out that entire company because they frankly did not know what they were entering into. But they knew the fact that that company has 2 factories in Uttarakhand, which have those licenses to manufacture, and they have plants and employees to manufacture wooden products, which is very beneficial for them. If they would have opened this plant and they would have done everything from scratch, it would have taken them 5 years. But they can, buy this ready-made from them. So instead of buying the company, they decided that they just want to buy the assets of that company, because then they zeroed in that all we need from this company is these 2 factories which are there. So fair enough, they went for that asset deal. Now, sometimes instead of cherry picking these assets, what they do is, and they buy the entire business of the company. That is, they buy everything on a going concern basis without actually cherry picking the assets. That is when you enter into a business transfer agreement. Again, everything in more detail as and when we progress. So this is just to give you an idea about what a merger is as opposed to what an acquisition is. So that's what M&A. Latest trends of M&A in India. Now, a lot of time when last year the pandemic hit us, the idea was, and everybody was really scared that, how will this affect the corporate market? There was a lot of uncertainty amongst the law students also, and everybody in the fraternity, even people who were practicing, that if this adversely affects the market, because if people don't have money to buy companies, if there's no mergers happening, no acquisitions happening, so how will it work out? But contrary to everything we've had, in fact, Khaitan as a law firm did one of its best business in 100 years. So, it was that good that in the past 100 years, the company had not done that kind of a business, which we did in the pandemic year, because there's been so much business activity which has been taking place. So left, right, and center, people are coming, they're buying companies, and we're getting a lot of foreign investment. People are showing more initiative than ever in buying companies. Obviously, the idea is that these are big companies which have huge war chests, and they had saved money for a rainy day, and when they saw an opportunity in the form of the pandemic, that's saying that people may want to actually buy out these companies, and they might get good rates for these companies, so they've gone really aggressive, and we've seen a lot of M&A taking place over the past few years. Obviously, the sectors which have seen a rise, and these are the sectors which are obviously, because the nature of the pandemic, the sectors which have seen the most rise are your fintech sector, edtech sector, and technology. Why? Because obviously these are the sectors which have gotten the greater push. Before the pandemic, this idea of digital India was mostly a slogan. Obviously there was a lot of push by the government, but people are a bit hesitant to accept the technology. But such is the thing about time that this pandemic has actually forced everybody to adopt this entire digital regime. So all these apps, you have your fintech apps which are there, from your Paytm to PhonePe to, there are so many others which have come up. Their valuations have hit through the roof. They've got so much investment because everybody is using them nowadays. because everything was shut down for the longest period of time. All our ed tech companies, because everything is now online education. Today, we are also, I would have loved to be present physically and have this lecture series with everybody over there, because I feel that's somewhere more interactive. But here we are. So everything's happening online. So these ed tech companies, they've gotten brilliant valuations. A lot of them have become unicorns, etc. And obviously, and other IT companies which are there. So, we've seen a great amount of business which is happening. So that's been very good. And those are, in the M&A sector, which we are seeing. Now, what is the journey of an M&A transaction? And where in this journey do we as lawyers fit in? Now, once we discuss this, we'll take a pause and we'll actually ask for questions so that, people with the initial questions which people have. So those can be taking place, because like Arushi said, the idea is to keep it as interactive as possible. It is for you to clear all your doubts which you have, and no doubt is right or wrong, or, important or non-important. Every doubt is the doubt. So just ask whatever you want to. So what is this journey of an M&A? Now, if you see, before the lawyers come into place, a lot of commercials have already taken place. Now, if today I have a company, firstly, I need to have an acquisition strategy and an acquisition criteria. Now, say as part of my business team sitting in a company, you decide that you want to expand your business. Now, if you want to expand your business, there are 2-3 ways of going about it. You know that your company currently you are market leaders. You've done brilliantly well within North India. So say in Delhi or in UP and all these states and Punjab, you have a very good customer base. You have a good supply chain over there of distributors who are helping you sell your products to other people, etc. So you've done well for yourself within these 2-3 places. Now you want to expand as a company. Now for that expansion, there are 2 ways to go about it. Either you can start from a scratch, enter the southern market, start from a scratch, find new suppliers for yourself, build customer relations, try and make a brand out of yourself, etc., etc. People do that, but that takes time for you to expand into a new market, because what you will need is you need to get to the end customer, you need supply chains, if you set up a factory over there, you need to figure out a local procurement of raw materials, etc., etc. There is a lot of things which happen, which will go into it. So now so that's one option, which is a time consuming option. The other option which you have is that you have enough funds and you've made enough profits that you maybe if you actually raise some more money, you feel that there is a competitor which you have, a company which is doing exactly the same business in the southern region. You are bigger than that company, you have more money, but if you buy out that company, overnight you get trained employees, you get a proper factory premise, you get plant and machinery, you get their supply chain, you get their distributors. So all you need to do is buy out that company. Correct? So that is your acquisition strategy. So you need to figure out what is the idea, what are you looking for, and what is the criteria you have. So the criteria in this case is that you want to expand to new markets. So the potential targets that you'll be looking at to buy out are the targets which actually give you those things. So which have a strong presence in that area, which have a good customer base, which have good and strong supply channels which are there, etc., etc. Then obviously, like a third step, is searching for the target based on the criteria. And now once you found the target, there's acquisition planning. How do you go about it? What am I doing? Am I merging that company with myself? If as an entity, what are the advantages and what are the disadvantages of that? Am I thinking of buying out that entire company from its shareholders? Again, what are the advantages or disadvantages of that? That needs to be thought of. Then what happens is that all I want is just to buy a few assets out and I don't need anything else. So then your acquisition planning takes place. Now that's fine. Now I figured out that I want to buy out this entire company through an acquisition. A share purchase agreement is what I'll do. I'll buy out their entire shares of the company. Then comes the valuation stage. So then the commercial people, they all sit on a table. They come in, they decide what are the commercials of the deal. Commercials of the deal are decided. You come to a value that, okay, finally I'm going to buy this company for 100 crores basis you, because the target company will give you projections to say this is what we are doing, this has been a business cycle for the past 5 years, these are our projections, because in the next 10 years we feel that if you put in money or if you buy out this company with the kind of money you have, we can really expand this. Then this valuation happens, their negotiation stage take place. Now, it is when this takes place that you mostly have a term sheet in place. Basically, the parties sit and they jot down 10, 15 strong commercial points on the basis of which they're happy to go ahead and do the deal. This is at this stage of the deal when, all this background work has taken place, then the lawyers come into the picture. Now, what these people will tell you, these business people will tell you is that, okay, it's fine. We've discussed, we know that we want to buy this company and we want to buy this for 100 crores. That's it. Now, you as lawyers figure out, do a due diligence. Figure out what is wrong with this company. Are there any potential roadblocks in this company? Because say, imagine that you are buying this company because that company has 2 factories, correct? And those 2 factories or 2 plants are there. And you want to buy it because once you buy those factories or buy those plants, you know you can really expand. And that will really help you increase your production. But if today, as a lawyer, when I'm doing the due diligence, I find out that that property in which those 2 factories are, firstly, they are on disputed land. So there is already a legal case which is going on in relation to those 2 factories. So there is a dispute which is going on. And it is that some indigenous people have made a claim that that land originally belonged to them. So there is a lot of dispute going on as to the ownership of that factory. Now, again, and now my 100 crore valuation was mostly based on the fact that those 2 land is acquired by you, is owned by you, and that will help me expand. But today, if I find out that you don't have proper title to that land and it's under dispute, then it changes the scenario. Because then, if tomorrow I actually end up buying that company and I lose the case in court, I will not have those 2 factories with me. So again, that adds the risk to it. So that's when lawyers are doing, they try to figure out what all are the loopholes, what all are the problems in that company. So that's when the due diligence takes place. Then once the due diligence takes place, there are a lot of concepts. Now, basis my findings of these on the due diligence process, we end up drafting the agreement. So either it's a share purchase agreement in this case because we want to buy out the company, or if the client would have decided that they want to go either for a share purchase, for an asset purchase, or a business transfer, we would have gone for that. And we'll delve into what makes you decide if an asset purchase is better than a business transfer as compared to buying out the company in a bit. So then basis that we end up drafting it. Basis that due diligence, whatever we found out. So if I found out that, say, the company has not been making its filings with the labor authorities in India, or if the company had, say, more than 100 employees and it was supposed to give them these many leaves in a year, but as per law, and they've not been given those many leaves, so we can ask them to rectify those mistakes as part of conditions precedent, saying that these are the 10 faults in your company. If you can rectify them within, say 30 to 60 days, fine, then we'll end up buying the company. Or sometimes you feel that, even after those faults have been rectified, the government can still come and fine you for this and put a penalty on the company. In which case you end up taking an indemnity provision. Because see, the idea is that the chance of that happening may be, say, 1 in 100 that the government can come and sue you for it. But still there is a chance. So you end up taking an indemnity saying that if tomorrow we are sued for this by the government and we have to pay the government 100 crores, you will repay us that 100 crores. So that is an indemnity which you take from that. So we do that. Then once the purchase and sale contract is done, then the business has to decide how do they need to finance it. Are they taking a loan, or how are they financing this transaction? Basis which, again, your financing takes place. If they're taking a loan to actually buy out the company, then we end up help them in making the loan documentation. And then obviously, finally, once the merger and acquisition takes place, the implementation part, which is again a commercial process. So this is how lawyers fit into the entire M&A deal process. So, that the drafting, because even when you're drafting those contracts, when you're drafting a share purchase agreement, or say if it's not 100% acquisition, but merely a fact that you bought 80% of the company, so you own the majority of the company, but 20% you still kept for the promoters, telling them that, listen, we know that your startup or your company is very good, but it is also very good in this plan that you've told us, this 5-year plan that you've told us. Very good. We buy 80% of the company, you remain with for 20%. Okay. And you help us achieve these targets in the next 5 years. And once you achieve these targets in the next 5 years, and if you are able to achieve these targets in the next 5 years, we will pay you an extra 100 crores and buy out your remaining 20%. So even if I've paid 100 crores for the first 80%, if you're able to meet these targets in the next 5 years, we'll pay you 100 crores for the remaining 20% and buy you out. So you keep them in the game. Now, so the idea is that when you have other shareholders also in the company, you have something called a shareholders agreement in place. Now, that shareholder agreement has to have all these terms and conditions which you have, and the negotiation. So that's where a lot of negotiation takes place, because that sets out the governance structure of the company, that who will have what say in the company. Can those 20% shareholders stop us from doing anything, or what are the rights which those 20% shareholders will have? Because those promoters may say that, okay, listen, that because if you want us to run the company for the next 5 years and give you the results, then we want a free hand. So we want that we should be able to take these 100 decisions of the company without coming to you every time, because you should only be concerned about the result. But obviously, if we are, say, tomorrow taking 1,000 crore rupee loan, we'll obviously need your approval, we'll need your everything for that. But otherwise, if it's something within a small amount of money, please give us a free hand to do whatever we want so that we can achieve our goals. So there's a lot of negotiation which happens about the rights, the legal rights, in the information rights, basically, and risk protection perspective. Because if you're buying a company, and as a lawyer, if you are representing a buyer in a company, you have to be very sure that you are doing this risk mitigation, and that you are making your buyer have the least risk when he's buying that company. Because the simple logic of any acquisition is that the risk and the liabilities of that company before the date you're buying them out is on the sellers, and after the day you buy the company is on you. So if there is any case, any penalty, any liability by the government, anything which the government comes after you, which relates to something which had taken place before the date of purchase, that should be on the seller. And then we as lawyers have to make sure that the documents clearly state this out. So there's a lot of negotiation and everything which happens. So yeah, this is how a lawyer, as a corporate lawyer, you fit into the entire M&A cycle. Now we can take a few minutes to take a few questions before we proceed, because otherwise this becomes a monologue. Have any of you done an internship before in corporate law firms? Do you know how an M&A process works? Have you seen anything happening? Do you have any questions about what all we've discussed till now? Things maybe you want to learn, or you want me to discuss in the next, over the next few days, a couple of days. Yeah.
So anyone who has a question can raise their hand, and they can switch on the mics, or they can drop the question in the chat box. Either way works.
Hello, sir. Good morning. Sir, you mentioned about the term sheets. My question to you is whether these term sheets are legally enforceable or not. Are they legally binding or what?
So a lot of times how companies want it commercially is that they go for a non-binding term sheet. So how we will structure a term sheet is that we'll say that this is a non-binding term sheet. It does not bind the parties to go as per the terms of this term sheet. And this is just a commercial framework for everybody to go about it. But if you commercially want, and the intention is that, no, we've sat on this table for 5 hours to come up with this term sheet. So this has to be a binding document. A lot of times you can put it in the term sheet that the terms of these term sheet will be binding on the parties, and that's what you contractually agree. But mostly and typically the customary practice is that term sheets are non-binding in nature, because the idea is that at the time when we are discussing purely numbers, a lot of it is just based on random projections. And a lot of these startups, they'll come with you with these 10-year projections to say that if you put 100 crores in us, or 10 crores or 50 crores or whatever amount, we can convert it into 500 crores, which sounds very good on paper when you're discussing it. But as and when your diligence starts, now diligence is not only legal, it's a financial diligence also. Because one thing is that you showed me papers. The other thing is that when I decide to buy the companies, I actually have my finance people or my accountants look into your books to see that if those figures are correct or not. So a lot of things take place, or a lot of things may come up going down the line basis my findings as part of the due diligence, in which case I may want to revise the price, or I may want to revise the terms. And it's possible that, in 50, 60 days today, I'm finding this deal to be lucrative, but say 50, 60 days down the line, things change and I don't want to go ahead with it. So a lot of time what happens is that you enter into a term sheet, which is non-binding in nature. The term sheet will specifically mention that this term sheet is non-binding in nature. And you have an exclusivity period that post the signing of this term sheet, for the next 60 days, the parties will try to negotiate contracts basis this term sheet. And if something reaches a logical conclusion, well and good. Otherwise, the deal goes off. So yes. So does that answer your question?
Yes, sir. Thank you so much.
Thank you. Anyone else?
So I think we can move forward. And
Yeah, we can move forward. If there is, then there is.
Oh, so we have, I think someone has raised a hand. If you can just take it up. Yes, Donika and Sugandha, if you could unmute yourselves in.
Yes, thank you for your address, sir. I had one question. So after all the negotiation takes place and the M&A process it is being closed, so what are the documents that are signed towards the end of this entire process to finalize everything?
So I'll tell you. Now, if we are, thank you for your question. Now, if we are buying the company completely, if I am acquiring all the shares of the company, in that case, we will enter into what you call a share purchase agreement. That share purchase agreement will set out, or an SPA as you call it, will set out the number of shares that I'm buying, what are the conditions precedent subject to which I will buy those shares, what are the obligations of the party. If you as a seller are selling me your company as a shareholder, if tomorrow I suffer any loss because anything which is false which you've told me, then who will pay for it and how much will you pay for it? It carries out all these things. So because a lot of times as a seller, you will say that, listen, you have paid me 100 crore rupees to buy this company. So if tomorrow you cannot claim anything more than that from me, because that's what you paid for. So my liability under this agreement is limited to the amount that you've paid me. So tomorrow you can't come and tell me that the government of India is fining you 200 crores and has levied a penalty of 200 crores on you. You can't come after me for all those 200 crores. I want protection and I want my peace of mind. So if you are paying me this amount of money, this is where my limitation of liability stands. Obviously, this is highly negotiated because the buyer would want that you bear everything that is there, all the loss that is there. And then you as lawyers for the sellers will have to push back and then commercially negotiate a common ground. But yeah, so in that case, you have a share purchase agreement. Now imagine if I'm not buying the company and I'm just buying a few assets of your company. For example, I'm just buying 2 IP. Say your company has developed a lot of softwares, but you have 2 IP which you generated, or 2, recently I did a gaming transaction and that company, it made games, 2 of which titles were extremely popular. So maybe you just want to buy those 2 gaming titles and nothing else from the company. So you go for an asset purchase. Or you like the entire business of the company as a going concern, everything, lock, stock, barrel, like it is there. But you don't want to buy the asset, you don't want to buy the company as a whole because you don't know about the historic liability, but you still want to buy each and every asset of the company and all the employees and everything as it is. In which case you enter into a business transfer agreement where you buy the company as a going concern. So that in that case, it's a business transfer agreement, or you have an asset purchase agreement, or you have a share purchase agreement. These are cases where I'm buying out the entire company. Now imagine that in addition to a share purchase agreement, a lot of times, like I was discussing, you may also have a shareholders agreement. Now, why do I have a shareholders agreement? Because it's possible that even after I'm buying the majority of the shares of the company, a majority is 51% or more. Okay? 50% or more basically. So even if it's 50.1%, I own the majority of the company. So if there's a change in control and I'm buying the majority of the company, but I may not buy the entire company. So in which case there are more than, there are different people or different investors on board in that company. You enter into a shareholders agreement setting out how will the company be governed. Because obviously there are different people with different ideologies, different mindsets who are sitting in the company, and you will have disputes. Today I'm buying the company, everything's hunky-dory, everything is good, fair enough. But tomorrow, if you end up fighting with each other, you should have a legal document which says how to go about it. Tomorrow, it should not be that if I want to start a new business, I'm a majority shareholder, and I want to start a new business and I want to stop the business which is currently being run. So that should not be the case that the minority shareholder, the 30% shareholder has no say in it whatsoever. So you can legally negotiate under the shareholders agreement your right that, okay, you run the company as you want. I am not interfering. You're the majority shareholder. But these are the 10 items which are generally called as affirmative voting items or reserved matters. If you are doing any of these 10 items, please take my permission. Because obviously I am in this company because your company is making cars, or your company is because your company is making steel or bricks or whatever. If tomorrow you are closing down that business and you're starting a new business, you will have to take my permission, because that is directly linked to my value in the shareholding value in the company. Because this company is 100 crore or 1000 crore company because you're making cars. But tomorrow, if you stop making cars and do something else, then I may lose the value that I have today, in which case, please take my permission. Or if tomorrow you are taking 100,000 crore loan or whatever amount loan you're taking, which is a very excessive loan, and that may lead to the company going bankrupt, you have to take my permission. So you can legally negotiate a lot of things regarding the governance of the company. And we'll discuss, when we discuss contract drafting in the final session, we'll discuss the outline of what all are the basic clauses that you need to look out for in all these documents. But yes, so these are the different types of documents you have. So you have a share purchase agreement, you have an asset purchase agreement, you have a business transfer agreement. And in case if you're not buying 100% of the company and there are some other shareholders, there is also a shareholders agreement. So that's from an M&A perspective.
Yeah, got it, sir.
That is that. Thank you. And I think there was one more person.
Yes, Sugandha this side. Good morning. Sir, so while it is abundantly clear how mergers and acquisitions work in the established companies and startup domain, I had actually read an article about simple agreement for future equity, which is being used in the US for new and up and coming startups, how they work and how they are being used as a convertible share. So, sir, I was wondering if there is a similar provision in India also for new startups.
Basically, for future equity. So that is when I'm giving a loan right now to the company and tomorrow I can convert it into equity. Sugandha, sorry, you're on mute. So
Yes,
is that what you're talking about?
Yes,
So in
yes.
India, so what we have started is that even in the foreign exchange regime, we have something called convertible notes, which you can give. Now, it obviously convertible notes means that I'm giving you a loan right now of a certain amount, and tomorrow you can convert that loan into equity. And domestically also, every loan you can enter into contractually at the time of giving the loan a term which says that you can convert that loan into equity. Companies Act says that if you have a provision, Section 62 of the Companies Act says that if you have a provision which says that your loan can get converted into an equity, you require a special resolution to be passed initially at the time of giving that loan to get that condition approved. But in India also you can do it. But frankly, as a market practice, that's not what startups want. Startups want, because see you're a startup and you are an up and coming startup. In addition to the money, you would also want a good name attached to you. So you would want a SoftBank to, be an investor on your board, because if they're an investor, they're sitting on your board of directors, they're part of the company, they bring in a lot more for you, and it adds a good brand value for you. So in India currently, the idea is that when people, they want to raise funding and they want to do startups, they go for pure funding only. They are ready to give you, so the instruments which they give you may vary. Now, not every time they will give you an equity share in the company. I may end up giving you a debenture in the company. Then a debenture is a convertible debenture, CCD in the company, or what you call a preference share. Both of these, you can convert them into equity shares at a future point of time. But obviously, they give them the holders the right to vote, and also all those voting rights and all can be agreed to. But in India right now, I think convertible notes and giving it as a pure loan as a concept is not that prevalent. In Indian startups, the people look for pure equity when they're going forward. The concepts are there. Legally, you can structure it as a loan which gets converted into equity, or you can give a convertible note or a warrant which can get converted into equity going down. Or it is possible, and which a lot of companies in larger scale also do, is that you can take NCDs instead of a loan, and the NCDs although do not convert into equity, it has to be a CCD. A CCD is a compulsory convertible debenture, and NCD is a non-convertible debenture. So a non-convertible debenture obviously cannot be converted into equity, into the shares of the company. But if you have issued them a CCD, that is a compulsory convertible debenture, that will convert into equity shares of the company. Similarly, there are other instruments which are there. But the most prevalent form of funding is pure funding, which happens. We don't have a concept of, although legally you can do it, but it's not something which is typically done.
Okay, so sir, like you mentioned, regular funding. So as per my understanding, it would be applicable where the valuation of the company can be approximately done. But for new startups, yes, sir. So for new startups, like the article that I had read, it mentioned that safe mode, or the simple agreement for future equity, it is used for those startups which cannot be valued approximately. So the companies prefer to buy convertible notes, and then they, after a few years down the line, then they convert them into future equity. So that's what I had.
So that's right. You can do it. See, it's a way of structuring a transaction. You can do it, and I can give you as a loan right now, or I can give you a convertible note right now, with the conversion being linked to the fact that the company achieves a certain amount of valuation at a future date. I can enter into a CCPS with you, I can say a convertible preference share with you, or any convertible instrument, with the idea that if your company in the next 5 years goes for a new round, so you're raising a new round of funding, and at that round of funding, if the valuation is more than an X amount of money, my shares will also convert to that amount, or at certain discount to that amount. So you can structure it as that way. A lot of times what happens in India, if you do valuations, right? So we follow this DCF method of valuation, or projection-based method of valuation, where a lot of times these valuations are based on the projections which you're making. So obviously one thing is these past valuations which you have, business which you've done, and one thing is the future projections which you have. A lot of these startups, these valuations which are there in India, and which is a problem, is that's why a lot of these startups, they go bust, and and they go bankrupt also, and a lot of these investors lose out on their investment, is that these valuations are all made in air. Because today you just have a concept in place, and then you're raising money and funding basis that. So the valuation, while you may put a lot of science behind it, frankly, ultimately, it's just the faith which you have in the promoters of that company, and the faith in their vision. Because see, like you said, if your company has been made just yesterday and it's just a plan, but you know that, okay, Kunal Shah or someone very good is backing this company, they've just made it yesterday, but maybe it's a very good company, or maybe these people are the ex-founders of this very huge startup. They sold that startup and now they're starting a new startup. So, maybe the idea is that this company right now has nothing on paper and there is no future projection. But if they are asking for this valuation, you can sometimes put in money basis that only, basis the credibility which they have. But yes, if you don't have that credibility in those founders and you still want to play a wait and watch game, like in a transaction which I've done very recently, what we did was that we linked the conversion price to the price at the next round. So if the next round, so we've told them that if in the next 3 years, you are able to raise 100 crores or more amount at a particular valuation. So if your post money, if your valuation of the company at that time is 1100 crores and more, then our conversion rate for that convertible notes that we have, or the CCPS which we have, will be linked to the price at which you are raising the funding. So because at that time you would have done 3 years of work, you will have a very probable valuation at hand. We link it with that. So you can actually structure it in a lot of ways basis of what is the commercial understanding that you have. A lot of times you may not want to link it to another valuation, is because if I'm actually linking it to another valuation, today you can buy 50% of this company, your shares, for at a lower valuation because the company has just started. But if I'm linking it to a future round of funding or a future valuation, the company may do brilliantly well in the next 3 years. And if your conversion at that point is linked to a very high rate of valuation, which the company has been able to achieve 3 years down the line, even at a discount, your number of shares that you'll end up getting will be lesser. Because if today, if you would have directly bought the equity at 100 rupees per share, because the company is just starting out and you can get a lower valuation, but you want to play a wait and watch game and say that 3 years down the line, whatever is the valuation, I may, say you give me the shares at that valuation with a 10-20% discount. Now that company may do brilliantly well in the next 3 years and that valuation may be skyrocketing, in which case you could have bought 50% of that company at 50 crores at that time, but now that company valuation is close to 1,000 crores, and even at a 20% discount at 800 crores, you're hardly getting a few shares in the company. So it's a commercial risk. Again, all these decisions end up being that what is your ultimate goal? Are you in it for a strategic investor where you want to play long term in the company, in which case you go all in, or are you merely as financial investor that you want to just make a quick buck, that in the next 4-5 years you just make a profit on your investment and just get out of the company? So it depends on a lot of that and commercial considerations, the amount of trust you have on the promoters, the people who are running the company. And yeah, that's how you make these decisions basically. But yes, I mean, just to answer your question, it's not an alien concept in India. You have that, and people do structure it like that. Maybe not use the exact terminology that is used in the US, but some form of that conceptually is already being done in the Indian markets. But again, that's not the preferred way forward.
Okay, and sir, how would due diligence work in this new startups regime?
But it's the same, right? So in a new startup regime, basic due diligence I'll do. But if you've just opened the company today, then what I would need to see is that fine, you may not have any historic liability, but still as part of the due diligence, if you want to run this company. Now, if you have started a company in a particular sector, say in an insurance sector or some other sector, where you require some very specific licenses in order to run your business, then as part of the legal due diligence, it is my job to make sure that you have all the licenses in place, you have all the permissions in place to actually undertake that business. So that tomorrow it is not that you've told me that you have, and say sometimes if I'm buying this company from you because you have this patent or this copyright or intellectual property or trademark that which is very good and exclusive, so I just need to make sure that you're the actual owner of that trademark, you're the actual owner of that intellectual property as part of my diligence, to see if the assets which I'm buying or which my client is buying, those are clean assets to which you have clean title. So that becomes very important. And obviously, as a new company, have you taken any loan or something which prohibits me from buying the company? Because a lot of times, if you've taken a loan to start your company, the creditor may have, as part of the loan documentation, a term which says that without their consent, you cannot do anything with the company, or you cannot sell out the company. So then obviously I need to make sure that there are no impediments on me buying the company that tomorrow. And it's not like, because you're starting the company today, you've gone around promising to people that, right now help me set up the company. And as and when I make something big, I will give you 10% shares. I will give you 20% shares. So you've been going around just distributing your shares of the company, orally promising it to a lot of people. So I don't want that to be a case that tomorrow I buy your company and we keep on getting hundreds of claims from people. So again, the legal due diligence, even for a new company, you have to make sure that everything is in place for them to actually expand and go what they're saying. So what they're telling you on paper should be what is there actually. So you still have to do that. Maybe yes, it makes our job and life much easier because there's no historic non-compliance that we have to look at. But you would still have to figure out what all is there in the company, and do they even have things which they're claiming for to carry out that particular type of business.
Okay, sir. Thank you so much.
Thank you.
So we have two more questions.
Two
So
more
if
questions. Yeah.
Shabazz can go first, and then Suresh, you could go.
Yes, thanks, Arushi. So, sir, my question is related to the practical aspect of how M&A lawyer would work. So what are the teams within an organization and an M&A lawyer would closely work with? For example, during auditing process, the auditor might need to contact different teams within the organization or the client for information. Yes, that's my question.
So I'll tell you. So how it works is that as part of when we're working with a company, now in a transaction, we mostly work with the finance team of the company and their legal team. A lot of these companies have in-house legal teams, so they'll have an in-house counsel. So their GC or general counsel and all of that company. So obviously we work very closely with the legal team, but we also work very closely with the finance team of the company and the people who are calling the shots. Because like I said, a lot of times when you're having discussions with your clients, a lot of times when you're having these, this entire discussion on what to do, how to do about it, you're having discussions with the other lawyers. Not everything can the lawyers legislate among themselves. You require financial sign-off because, like I said, there may be a particular risk, which is a 30 crore risk. So for me on paper, that's a huge risk that is there. But then I will have to discuss it with the financial team of that company, which may say that, listen, that we are expecting that this company will give us, say, I don't know, 300 crore per annum business or whatever annum, amount of huge number business over the next couple of years. So it doesn't matter that even if there is this risk of 30 crores, we still want to go ahead. So don't make it a huge deal out of it. If they're ready to bear it as in specific indemnity and pay us for it, well and good. Even if that's not the case, we don't care. In which case, obviously, they've taken a commercial decision and they're ready to move ahead with it. So you don't bother. So we obviously have to interact with the finance team of the company and the legal team of the company. Also, another department through which we closely will be interacting is the HR department of the company. A lot of times, a lot of your labor compliances in a company are done by the HR department of that company and not just by the legal team of that company. When you're onboarding employees, you have to do a lot of paperwork. You have to under the law, you have to pay employee state insurance, your ESI, your EPF. A lot of contributions need to be made. So all these labor law related compliances are sometimes run by the HR department. So with that department, you have to coordinate a lot. So you're mostly this only. So your finance department, your HR department, and your finance, HR, obviously the legal team which is there. And then sometimes there are issues which even they cannot take a call on. And say today we've been negotiating this deal for the past 1 month and one for the past 2 months, and now we've just come down to one or two very critical points which lawyers on both sides are not willing to give up. I tell this finance team over here that, listen, this is huge. If tomorrow something happens, the government of India can change its policy, and if they come after you, you may end up jeopardizing your other businesses as well, because then the government will have an inquiry against this one business, and as part of it, they'll go and dig into your other businesses as well. So it's very problematic for you. So then the finance team may not be able to take that decision themselves because I've taken it to that level. And similarly, the other side lawyers may say that no, this is highly unlikely that the government will ever do this. So we are not ready to take the risk for this because it's highly unlikely that the government will ever do this. So the lawyers are not able to reach a consensus. The finance teams also, because I've raised it to such a level saying that, if you end up doing this or if you say this is okay, it may lead to a huge loss for you. They're also not doing it. So then ultimately, then we have to then have a call with the main management of the company, the CEOs, the CFOs, or whosoever is calling the main shots of the company to figure out. And when that's called a principal level decision has to be taken for something. But yes, in an organization, from a day-to-day legal perspective, you will be dealing with their finance teams, their HR teams, and obviously the legal in-house team which they have with a lawyer.
Thank you, sir.
So if at this point, if I could just ask a question for the benefit of the first year especially.
Yes.
So in the practical sense, how long is it that a merger processes for? So for example, what is the cycle that is required for one merger? And on that, during the process of the transfers of, say, the control or say the assets, what happens if a merger midway is set back? So how do the two companies resolve that situation? Because it's not like that at one particular day everything gets transferred. So how is this process regulated? If you could please
So
focus on that.
when you talk about merger per se, so that's the court-driven process, the tribunal process which we are talking about, right? So when two entities are merging together to form one combined entity. Now that merger process in India generally takes 6-7 months minimum because it's a court-driven process. You will have your merger schemes, the court will have questions, your scheme has to be approved by the creditors and shareholders of the company. Now, as part of the merger exercise, you are actually combining two companies and you're forming one company. The idea is that as part of this exercise, ultimately, you should have one running business which is there. What does that entail? Firstly, your assets have to be under the name of all that one company. All your assets, all your lease deeds, all your contracts. Now till today you were having a contract with this company B Limited, but after B Limited has merged with A Limited, there is only one entity A Limited which is left. So all your contracts will get novated to A Limited which are there. All your assets have to be in the name of that company. All your employees will shift from the books of B Limited to the books of A Limited. A lot of these processes will take place, and obviously back-end implementation takes time. Technically, what happens is that from the date of the court order is passed, everything what it says is that will stand transferred to the other company. So from the legal procedure, once that merger order has been passed by the NCLT, your merger is taken place. So that's a successful merger. You can pull out from the time when you're filing it till the time it's not been approved by the court, you can pull out. But once the court order has been filed, then legally it's one entity. Then you don't need to do anything. Then by operation of law, you are one entity. Then it comes from the implementation perspective, that implementation of that assets take place. Now, if you are not doing it for whatsoever reason, so today, as per the court order and that court approved NCLT scheme of merger, you are supposed to transfer all these assets in the name of A Limited. But tomorrow, if B Limited says now we don't want to do it, that's not how it will work, is because then I will have a legally binding document as part of the court order to compel you to do a specific performance of what you have to do. So then that's again another litigation. But it won't happen that halfway through. It can only happen once commercially we are discussing and things are happening and the court has not passed the order till now. But it's not like the court has passed the order. I have an order which says that everything will be merged into one entity. And tomorrow, after everything is being done, you decide, I don't want to do it. So you can't unilaterally do that. But then I will have a litigation against you.
Right. Suresh, you have raised your hand. Do you have your question or should we?
Yes, thank you. Good morning, sir.
Good morning.
So can the promoters raise their share in the company through open market purchase in the exchange, like the GI promoters has been doing?
Sorry, Suresh, you're not clear. Can you repeat it? Sorry.
Yes, sir. Can the promoters raise their share in the company through open market purchase in the exchange, like the G promoters have been doing?
Stock exchange, what are you saying?
Yes, sir. Yes, sir.
No, so stock exchange where you can only sell your shares if you're actually a listed company, right? So if you're a publicly listed company, in that publicly listed company, the process will be different. Yeah. So if you just take a step back, now a normal process which we're talking about, doing a pure SPA, buying the company and everything, is a separate thing. But if you're a publicly listed company, so in India, there are two things. And when we'll be discussing in the next half of this today, the legal process, we'll discuss what happens in a public listed company as well, public M&A, what is that? But just to give you a flavor of it. Now, if you are a company which is listed on the stock exchange, in addition to the Companies Act, you are also governed by the SEBI guidelines which are there and the SEBI regulations which are there. The SEBI has something called a takeover code. So that's the SEBI takeover code is there. Now the takeover code says that if today you as a buyer are making a offer for buying the shares of a company of 10% or more shares of the company, then you have to go and make an open offer. and that open offer has to be of a minimum percentage of shares of the company to all the public shareholders and the other shareholders of the company as well. So then you have to follow this proper regime which is there. So only the people of the publicly traded company, those promoters, can actually sell their shares in a stock exchange. If you're not listed on a stock exchange, the promoters can't go and sell their shares just like that in a stock exchange. So there's a process. So you have to be a publicly listed company, and then if you're a listed company and you're selling your shares, you can sell it either through the stock exchange or offline from the stock exchange through another process which is there. So SEBI has different processes for these, but it is only for public listed companies. For if you're a private company cannot sell its shares. You can dematerialize your shares. What can happen is that they're either physical shares or they're shares in demat account. So demat shares are dematerialized shares which you have a depository participant, but it's the same thing. It's just not, instead of having it as a physical share certificate, you have dematerialized shares. But for you to sell your shares in a stock market, you have to be a listed company.
Okay, thank you, sir.
Yes.
So we'll take one last question and then we can move on with the lecture. Mohammed, if you could if you could unmute yourself and
Yeah.
Yes, sir. So thank you for this. So my question is regarding, I have a confusion regarding the definition of merger itself. Like I read somewhere that differently, that is it a merger is that only two entities A and B, and they joined together and they created a third entity C, and this both A and B get seized out, or like they cut off from the registers, or it's like it can be happened by A getting into B and A becoming seized out. Is the both way happens, or like only?
So what you were talking about for two of them to merge and form a new company? No. So merger, what I see in a practical sense, the term merger is not defined either in the Companies Act or in the Income Tax Act. There is no definition of the term merger which is there. As a concept, merger is a combination of two or more entities into one, basically, and the desired effect being that not just the accumulation of assets and liabilities of the distinct entities, but also organization of such entities into one business. With obviously, like we discussed, the possible objectives being economies of scale, acquisition of technologies, access to varied sectors, etc., etc. So, and generally in case of a merger, how it will work is that the merging entities would cease to exist and you will have one single surviving entity. So like I said, A and B merges into A. So you have one single surviving entity in A. Again, but the Income Tax Act sets out a term called, analogous term called amalgamation. Amalgamation is the merger of one or more companies with another company, or the merger of two or more companies to form one company. Correct? Now, if you, like you were saying, again, if I am part of my amalgamation process, if that is how I want to play it, that I want that I have made a new company C, and my merger will be then that A and B cumulatively combine into C to form one new business entity. So then my amalgamation scheme in itself will have three entities. Getting? So my amalgamation scheme will have three entities in which I am saying that I've made this new company C, which is a joint venture between the two parties. Now, as part of the joint venture, you are entering into a amalgamation scheme, and then both of them merge into C together. In which case, both A and B will cease to exist, and the only company you will have remaining is C, in which all the assets, liabilities, and everything of those two companies, A and B, merge into C. But if you see the Companies Act per se, the Companies Act does not have a definition of what is a merger. Even the sections which are there, 230 to 234 and all, it's called schemes of amalgamation and other compromises which the company's shareholders enter into. Because that way the Companies Act and the government gives you as shareholders a lot of flexibility on how you want to structure your amalgamation process, obviously subject to it being passed by the NCLT and the shareholders and creditors of the company.
Okay, sir. Also, is there any? I mean, have ever it happened in India that A and B join together, as you mentioned, and then get into C? Is it happened in India, or like only the first way?
It may have. It's not something. It's possible that would have happened previously, but mostly, typically, what you would see a merger transaction is when two more companies come together to form one company. And it's generally, if you see, so like if you would have read this latest one in which they're saying, I think Sony and Z are merging, the idea is that ultimately everything will merge into Sony or everything will merge into Z, and you'll have one company which is left, and not that both of them combine together to form another new entity.
Okay, sir. Thank you, sir.
Thank you.
Right. So I think we can go ahead with the lecture.
Yes. Now we can proceed. So, but no, it's good. I think that's what's good. It's like you end up, having all your doubts cleared, and you have an interactive session that way. Now, how you acquire is as important as what you acquire. Now, again, I want to buy the company, but what are the parameters which will make me decide whether to go ahead and buy this company as a share purchase agreement through acquiring the shares of the company, or as an asset purchase, or as a business transfer? Now, there are different reasons why people would go for a certain thing over the other. So obviously, one of the most fundamental considerations in any M&A transaction is the mode of acquisition. So I'm going to just have water. Now, firstly is, now like I discussed, we have a share purchase of an acquisition of a full acquisition of a company. Now, why would I want to do that? I would want to buy the entire company because it's very, it's well done. The company is working properly. The company in itself has a very good business standing and it has a good goodwill. The name is good. All your employees are in place. A lot of time what happens is that you have specific licenses which are there. Like recently we were doing buying a company out, and we were buying a company because that company had a particular forest license in place, which is given to the company. It's company specific, correct? Now, so if you buy the company, you get that forest license. And because of the COVID situation, the new licenses were not being given out that easily. So if our client wanted to get that new license, it would have taken them 2 years. So it was easier to buy that company. So, they wanted to buy the company, but they only wanted that company because that company had those 2 factories which had those licenses which were there. Alternatively, the other option which they could have used is they could have done an asset sale. But in case of an asset sale, what happens is that you're buying the assets of the company, but not the company itself. So this license which is given to the company, then it becomes again useless for you because you'll have to go and take a new license. So even if you have the factory, you have the plant, you have the employees, when you're buying the asset or the business of the company, you will not have that license, which brings you back to your zero position, because what you need is that license in order to carry out the business. So I go for a share purchase in that case. But like I said, that and that is again becomes a business consideration, because if I'm buying the company, and if I'm buying the company and that company has a lot of historical liability, I would still want to go ahead with it, because the risk is that I lose out on 2 years of business because I'm not getting that license for the next 2 years. So you would take that risk irrespective of the fact, because you want that license which is there. So there are many considerations which are there in case of an asset transfer. So if you can go to the next slide also. So the types of M&A. So there's tribunal, share acquisitions, and asset and business acquisitions. Tribunal approved schemes, we've discussed at length how those works. Tribunal approved schemes are, when you're merging 2 companies. Share acquisitions is when you buy out the company completely. Now, just if to take a step back, what happens when you're buying the complete company? You get all the litigations of the company. You get all the liabilities of the company, all the loans of the company, correct? Every non-compliance under law that you've done is in the name of a company. A company is a separate legal entity. Now, when you're buying that separate legal entity, every liability of that company also comes on to you. So tomorrow, if somebody wants to sue the company, they will come after you because it's your company. You are the shareholders. You are the owners of the company. So there is a lot of liability and risk which comes while you're buying a company. But still at that time, a lot of times you want to buy the company because that company has everything, in place. It has all the licenses in place. It has all the government approvals in place. Even small things. If you're into if you're doing foreign exports, right? Foreign exports, you're doing under a lot of these government schemes. So that company has entered into a lot of schemes with a lot of companies which are there, and you are getting for the government under a lot of government schemes. A lot of subsidy comes to those companies, and that everything is going in a smooth mechanism over there. If you end up just buying the assets of the company, not the company itself, you will have to again start and do all those things from a scratch. So maybe you don't want to do all of that. So all you do is, at that time, you go and you buy the company as a whole. It is possible that now you think that you already have that license in place for another factory of your, because you running those other factories in, suppose this was in Uttarakhand, so you have.
Sir has some.
Sorry, Arushi.
No, sir. Actually, she was under a misconception that your internet is being erratic. It was on her side. We apologize. Please.
Okay, no worries. What I'm saying is that but then you are doing a part of the diligence. What we find out is that that company has a lot of historical problems. So maybe buying that company is not the correct thing to do. In which case, you can either buy just the assets of the company, or you can buy the business of the company as a whole. But the problem with that is that when you're just buying the assets of the company, at that time you have a lot of tax implication. Now there is a tax implication from the seller side also and the buyer side also, when you're buying just the assets of a company, or when you're buying the business as a whole as a slum sale. When you buy just the assets of the company, your capital gains tax, your tax is payable to both sides on each and every asset that you're buying. Right? So then the value of each and every asset is taken into place when you're buying it. Now in India, what happens is that you have a short-term capital gains tax and you have a long-term capital gains tax. If I bought something which was around more than, if I've owned something for say 12 months or more than 24 months, and then I'm selling it, the amount of tax is lower as compared to me buying something today and selling it tomorrow, or within that small short period of span. Now, when I'm doing just an asset purchase of a company, I will have to pay that tax on each and every asset. So depending on when that particular asset was bought, I will have to pay the tax. Sometimes it turns out to be a large amount of money. But if tomorrow I'm doing a business acquisition in which I'm saying that I'm not buying the company, but I'm buying the entire business of that company, lock, stock and barrel on a going concern basis, then what they call a slum sale, then that tax is payable only on the amount, the overall amount of the slum sale. And what is taken into picture is account is since when are you owning the business of the company, and not when you've owned that particular asset. So that helps you reduce your tax liability. So generally why people prefer a business transfer agreement over an asset purchase agreement, if assets are all you want and you're not buying the company, is that they prefer a business transfer, because in a slum sale, the amount of tax is much lesser for you. So given that there are a lot of these considerations which you have to consider on figuring out whether or not you want to buy the company. Again, I think this was Arushi was also had this question, and now I can give you 2 more minutes on this. Firstly, then NCLT sanction machine. Just to recap, tribunal approved schemes, NCLT sanction scheme. You make a scheme, you go to the NCLT. The NCLT has to be okay. The NCLT is the National Corporate Law Tribunal, which is there. Now, what the government has done is a lot of these commercial things which are there, company law related matters which are there, or disputes which are there. So instead of you going to the high courts and the district courts and all of these courts, you specifically go to these tribunals. So you have the NCLT which is in place, which looks after all of this. Shareholder and creditor approval is required in order for you to pass any scheme of amalgamation which is there. You have to have a shareholder approval and a creditor approval of 3/4 of the population of the shareholders and creditors, which is 75% or more. Correct. What the merger does give you is continuity, because all the companies they seamlessly merge into one company. So everything goes as usual, those companies form one. Obviously, there is a lot amount of implementation which has to take place, because one company has a different working style, the other company has a different working style. When you're merging them together, you have to have a common philosophy. You have to, attune the people to your style of working. So all that happens, but obviously it gives you a sense of continuity because everything gets transferred into the name of the merged entity, which is there. In case of a tribunal scheme, there is a transfer of liabilities. Now, you can't cherry pick when you're actually merging two companies to say that I will not be responsible for A or I will not be responsible for B. When you're merging the two entities, all the liabilities of that company, be it the loans of that company, the previous non-compliance of the company, whatever is there, all those liabilities end up getting transferred to you. So you don't get to choose whether or not you are keeping it, because one of the major ideas of this transfer process is that it's transferred as a going concern, and the amalgamated company is issuing the shares to the shareholders of the amalgamating company on a proportionate basis. So it's on a going concern basis, so you can't actually get to choose what you're doing. All the employees will get transferred, and as part of the merger scheme, those employees, all the previous benefits, all the accrued benefits of that company are transferred on a continuity basis. So if I am an employee of the company, how it works is that under Indian laws, if you've been an employee of the company for more than a certain amount of time, say I've been an employee in this company for more than 5 years, then after 5 years, I am entitled to gratuity when I retire or when I leave the company. But which will not be the case if I just leave this company and join a new company. But in case of a merger, there is continuity of your employment as well. Your employees are transferred. There is continuity of employment, which is there. So it helps you also. All these licenses and the government approvals, which I'm telling you, all of them will get transferred in your name. Correct. Obviously, as part of the merger and approval merger process also, if you are in a regulated entity and if you are part of a regulated setup, you would need to take approvals from all the government entities as well in relation to the merger. So the NCLT will require you to show them that you've taken an approval of the merger. Because say in case two insurance companies are merging, then it's not the NCLT alone which can decide. You have an insurance regulator, you have the IRDA which is in place. So that IRDA also has to give you an approval for merging your two companies together. Sometimes the two companies are so big and they're so huge that it can create a competition law problem. So the competition law, because what is competition law? And, since one of our, my partner had told me that competition law is nothing but an apology to capitalism, because you have two huge companies coming together and you want to make sure that that does not lead to any particular disadvantage to the smaller companies. So in which case there are certain threshold limits which need to be checked. And if those are being breached, then you require a competition law approval as well for that merger. So that's CCI approval. So then your scheme is subject to you getting a CCI approval. So a lot of these other third-party government administrative bodies which are there, you require their approvals as well if you are in that regulated sector. And once everything is done, then this merger process takes place on a court-approved merger by the passing of the NCLT order. The merger is effective from the date of the company order which takes place. And the payment of consideration typically in case of a merger is through issuance of shares. So there's a share swap per se, that instead of me paying you money for buying out your company, for merging your company, the shareholders are given shares in the new final entity, which is there. That is that. In share acquisitions, what happens is, again, your acquisition by purchase of shares and stocks of the company. You go and you buy the shares and stocks of the company, which are the ownership units of that company. Purchase is through a share purchase agreement or a security purchase agreement, which is there, which we've already discussed at length. Then purchase of the company as a whole with assets and liabilities. Like we discussed previously, when you buy the entire company out, you cannot pick and choose the liabilities which you are taking. You take the company on the whole with all its assets, all its liabilities. So if tomorrow anything happens, it's on you who is the new buyer. You cannot choose that this is what you're taking or this is what you're not taking. You take the entire assets as a whole, as a concept. The business continues on an as-is basis when you're doing a share purchase agreement, because you bought over the company. So the company remains the same. That company is a separate legal entity. So the company remains the same, everything remains the same, things go on as usual, which are there. But only the owner changes at top. In which case, all the licenses, government approvals, and everything which you've taken, they continue to exist. What only happens is some of these licenses or some of these government bodies, they require you to take their prior approval in case of a change in control, which is still an easier process than actually going and taking a fresh approval or starting something afresh. Correct. So one of the advantages of buying this company through a share acquisition is that you buy the company on an as-is basis. Everything goes. Your employees were employees of that company yesterday also. They remain the employees of the same company today and tomorrow as well. So there's no change in the employees. Everything is going as usual. For them from the, everything is in place. The owner is changing. So tomorrow, instead of A being the owner, B is now the owner, but everything else remains the same when you're doing the share acquisition and SPA route. Obviously, there are foreign exchange control implications and pricing guidelines need to be followed. Now, what are these foreign exchange control implications? So in India, you have an exchange control regime, right? You have something called the FEMA, Foreign Exchange Management Act, which is there. Under the FEMA, we have, the government releases, you have an FDI policy which comes into play. And in addition to that FDI policy, you have the NDI rules, which are the non-debt instrument rules, which are there. So the FDI policy along with the non-debt instrument rules is what basically governs FDI in India, foreign direct investment. Now, in any case, in India, like in any other country, government wants to control the amount of foreign money which is coming into the company and the amount of foreign currency which is going outside the country. Now, when money comes into India, under FEMA, there are certain sectors under the FDI policy where money can come under 100% automatic route. And there are certain sectors where you require government approval in order to take foreign money. Mostly now because we're moving towards a liberalized, liberalizing the economy more and more. And the idea is to promote ease of doing business in the country. So you don't, so you would see that in a lot of sectors, every day you keep on hearing that the government has made it 100% automatic route. 100% automatic route means that you can get foreign investment into that company without actually doing anything, in the sense taking any governmental approval. But there's certain sectors, say the media sector, the digital media sector, or the insurance sector, or certain defense sector companies which are there, in which if you are taking foreign investment above a certain threshold, you will require the permission of the government. Mostly these things are done from a national security perspective, that you want to keep things in control. Recently, in the last 1 year, a thing called PN3, which is Press Note 3, came out with the government, which amended the Indian foreign policy to say that every investment which is coming from a landlocked country, a land sharing country, a border sharing country, mostly with China in mind. So if a Chinese company today is investing in India, they would have to seek prior approval of the government. So that's how they've noted. There is a lot of, gray area over there, because it says that any company which has, Chinese company has significant influence. So then the definition of what is significant influence, a lot of people try to play with. But currently, in the absence of any beneficial interest, the definition clarification coming from the government, a view in the market is that any investment, any company which has investment from a Chinese company, and if that company is putting in money in your company for an investment, you would require prior governmental approval for it. So as simple as that. Now, pricing guidelines are also, so when money is coming into India and when money is going out of India, the considerations are different. When money is coming into India, the government will want that the Indian company or an Indian seller who's selling the shares of his or her shares in the company gets a minimum of the fair market value of the company. Because obviously the government will want that as much money can come into India and you're not underselling your shares. So it's not like any foreign company is coming and buying Indian shares at dirt prices and going back. So that's not allowed. You can only sell your shares, and a foreign company can only buy the shares of an Indian company at a minimum of fair market value. If an Indian resident is selling to a non-resident, the idea is that because you're selling your shares, money is coming into India, you should get maximum amount of money. So there is a floor. The floor is the FMV, the fair market value of the shares. You do a valuation of the company, and based on the valuation of the company, you cannot get lesser money than that when you're selling. The opposite of it is that when an Indian is buying shares of an Indian company from a foreigner, so say a foreigner had initially bought the foreign resident or a foreign company had initially bought the shares of the company, and now they are selling that share. So in that case, what is happening? Money is going outside India. So what will the government want? The government will want to put a ceiling on it. So what the government says as part of the pricing guidelines is that if I am buying the shares of an Indian company from a foreign company, the maximum I can pay is the FMV. So whatever is the valuation report is done and whatever is the valuation of that company, that is the maximum amount that I can pay. Above that, I'm not allowed to pay. So if you're doing corporate law and if you do working in law firms, you will have to make the FDI policy your best friend. You will have to read the FDI policy because that tells you what all are the restrictions which are there. Now, a lot of these sectors, like nowadays, we get a lot of work because a lot of developments are happening in the e-commerce space. So a lot of these e-commerce entities, are getting in money and they're getting a lot of investment. Government has rules for it. So government says that e-commerce may, if my company today is running an e-commerce platform, then I can get 100% FDI under automatic route. Because what is the e-commerce company doing? The e-commerce company is merely acting like a platform where it connects a buyer to a seller. So you don't own the products that you're selling, which is fine. Amazon mostly doesn't sell its own products. So I can, as a seller, register on Amazon and I can sell it to the customer. So Amazon really acts as a platform, which is allowed. You can get 100% FDI. But the government says that the moment you own the inventory, so if today Amazon owns the products that it's selling and it's just onward selling through its platform, in that case, single brand retail through e-commerce is not allowed. So then I will not be able to inventory-based model, basically. Inventory-based model, you cannot get foreign funding. The idea again is to protect the interests of the common, your shopkeepers and the kirana stores which are there by not allowing foreign money into the country for this. Because as you would see now, because then the amount of discounts these people gave, the amount of, the money which comes to foreign companies, it puts everybody else at a disadvantage. So as part of that protectionist regime which is there, you have these things in place. So you have to know whenever you're dealing with a client, you have to know what is there in the FDI policy. You have to see whether the sector in which this investment is being made and you're getting a foreign investment or a foreign buyer, is it even allowed under the Indian law to buy that company, for a foreigner to buy that company? If yes, what are the restrictions and what are the conditionalities for that investment to come into place? So when you're buying the shares of a company, it all becomes very important for that as well. Lastly, the pricing has to be done properly. The foreign exchange has to be made sure that your government allows you to do that, and etc. etc. Lastly, like we've discussed at length, and due diligence of historic liabilities becomes very important when you're buying a company or acquiring a company, because again, you will be responsible for everything upfront. So historic becomes very important. Now, asset and business acquisitions. The other type which is there, and so this is the last point which we'll discuss, post which we'll take a few questions and then we can take a break before we delve into the legal aspects. Now we'll discuss each and every section and on the laws which are there. Before that, asset and business acquisition. Now, acquisition of business can be through either a transfer of the entire undertaking as a going concern or transfer of just the cherry-picked assets that are required for the business. Like I said, the biggest difference between these two things is ultimately the fact that the tax implications which are there. And also, what's the ultimate intention of you buying that business? Is the ultimate intention of you buying the business that you want everything? Because if I'm buying this company and you feel that, okay, even if this company has a lot of historic liabilities and I don't want to buy the company per se, but I still want the entire business as a going concern. Going concern will mean that I'm buying everything. I'm buying things, I'm buying the factory, I'm buying the appliances of that company, and I'm transferring all the employees of that company into my books. I'm taking each and everything which is required to run that business as it is from their books to my books. I'm just buying everything out. Asset purchase will mean that I'm just identifying that what I need to do is I need only your employees to get transferred to me. You have 100 customers. I don't need all 100 customers. These 50 contracts which you have with 50 customers, you can novate these contracts to me as part of the transaction. And you have 10 factories. I don't need 10 factories. I just want these 3 main factories or these 3 main businesses that you business establishments that you have. I just want this. So I cherry pick these assets and then I buy them because I don't need anything else. I know that this company that I'm planning to buy or the assets from has businesses all over India, has presence all over India. But I'm already strong in North Indian territory. I don't need to buy that thing. I only need it for the certain area which is there. So I don't need to pay money for buying the entire business. I can just cherry pick and say that this region of your business is what I want to buy. And usme bhi I can tell you that I just want top 10 customers or top 15 customers or whatever I want. So you get the idea of cherry picking the assets. So depending on what, like we said, when we discuss the cycle of an M&A, what your acquisition strategy is and what is the purpose of your acquisition, basis that we decide what is the mode through which we are buying the company or buying the assets. Like we've discussed, assets can be purchased through an asset purchase agreement, and while business is undertaken through a business transfer agreement. It's called the buying on a slump sale basis or through a court-approved demerger. Now, what a court-approved demerger is that either I can actually enter into a business transfer agreement and buy these particular assets and business as a going concern from you. Or what happens is there's a court-approved demerger process in which, again, as part under section 230, 234 of the Companies Act, you go and you demerge an entity. So you carve out the business. So in my business today, I have 100 units and different factories and everything. I demarcate a particular area of my business which you want to buy. And through the court proceedings, we demerge that into a separate business company. And then that company is either merged with your company or it becomes a separate company which you end up buying. So business transfer can either be through a slump sale process through contractually or through a court-approved demerger process. Tax considerations between an asset purchase and business transfers ultimately end up being one of the most important differentiators when it comes to companies to decide whether or not they're doing an asset purchase or a business transfer agreement. Because this difference between 20% tax and 30% tax between long-term, short-term, whatever that figure is, in a large-scale transaction, it ends up translating into a huge amount. So you have to take a call basis what are the assets of the company that you want to buy on whether or not you want to go to the business transfer route or an asset purchase route, because that will have tax consequences. Issues in relation to employee transfer. Now, when I'm transferring the employee through an asset purchase agreement, I would then have to figure out what is the whether I'm taking the employees on a continuation basis, on a going concern basis, or is it a fresh piece of employment? A lot of times what happens is that under Indian laws, you have to pay retrenchment fee to the employees. Employees are actually entitled to a lot of other benefits which are there as part of their employment. Now, one way of going about it, and which is a clean way of going about it, is if you ask the employees to tender in their resignation letters, and then you accept their resignation and then offer them new employment under the new company where the assets are being transferred. Why people prefer to do that as a route rather than just terminating the employee and then asking them to join the other place is that because when you terminate an employee or when you're removing an employee under Indian law, you are required to give them a lot of retrenchment or severance bonus or severance money which is required to be given. The labor laws set out a lot of things that are required to be paid contractually. Plus, it increases your liability. So a cleaner way to do about an employee transfer is that if the employee obviously himself or herself is resigning, then it's not a problem. The labor laws will only kick in if you actually remove that employee. So how you structure it also becomes important. You need to make sure that the employees are given equal or better terms in the new company, etc., etc. So again, those asset and business transfer acquisitions, you have to just structure the employee transfer as well to make sure that it's most cost efficient, as opposed to just buying the company out, in which case it's no problem. You don't need to structure all of these issues. Continuity of contracts, licenses, etc. In case of an asset transfer or a business transfer, the biggest problem is that you need to take the approval of each and every contract that you're transferring, because it's not as easy as if I have a contract and I just tell them that, okay, as part of the asset transfer agreement, these 50 contracts with these customers, you take over. No, you will have to novate those 50 contracts, and a lot of those contracts, or almost every contract, will say that you cannot assign the rights under this contract without the prior approval of the other party. Correct. So in which case, then I have this new added headache of going to all those 50 customers, taking their approval to transfer their contracts. Some of them may give an approval, some of them may not give an approval. Some of them may use this as an opportunity to renegotiate their contracts to get better terms for themselves. So that is an issue. Licenses, like I told you, majority of these licenses are in the name of the business, in the name of the company, and not in the name of the connected with the asset that you're buying. In which case, if you just buying the assets of that company, you have to go and take a fresh license for that company, etc. So these are a lot of factors which go into place when you're actually deciding what to buy and how to buy. So more than what to buy, it becomes very important from a legal perspective is how you buy. And this is where we as lawyers come to the picture as well. Because obviously there are commercial considerations, but sometimes the client says that, listen, I am open to everything. I can buy this company out, I can buy the assets, I can do a business transfer. But you're my lawyer, tell me which is the most legally sound method for me to go about this company. And that is when the lawyers will actually tell them that, okay, listen, that under law, these are the 10 ways in which you can buy this company. These are the advantages and disadvantages of everything. And then you help them make the informed decision. These will again depend on the scale of the company, the size of the company, and the other things which are there in the company. And you have to take a very well-informed call at that time. But obviously, like I said, mostly all of this is commercially driven because there are commercial incentives behind it. But that is not to say that the lawyers have no part to play in it, because obviously the fact of whether or not the company has historical liabilities is something which comes from your due diligence, from what you are finding as part of that company. So what we've discussed right now is what are mergers and acquisitions in India? What are the different types of mergers which are there? How are the different ways in which you acquire a company? Now what we're going to do after this, which is in the next session now, is that we will discuss the laws which are there. Now it's very good that, a lot of these things are there that you will be running, but what are the laws? So differently, just to give you a flavor of it, there is the Companies Act, which is there. Now, anything when you're dealing with the company, buying or selling of a company, buying the shares of a company, board meetings of a company, anything relating to the company, it is your Companies Act which plays the most important role. Obviously, if you're a listed company, in addition to the Companies Act, you have to look at the specific regulations which SEBI, which is this Securities Exchange Board of India, SEBI has a lot of rules and regulations which in relation to listed companies. So obviously, if you're a public listed company, you need to look at all those regulations as well. Then, given the size of the company and the scale of the company, you also need to look at the Competition Act to see whether or not that particular transaction is notifiable under the Competition Act, the CCI. Then obviously when shares of company or anything of the business of the company is related, you also need to look at the FEMA, the foreign exchange rules, the FDI policy of the country to make sure that whether a foreign company can buy the shares or not, or even the assets of a company. So in the Indian law, if you buying a company, then that company can own property, but a foreign company cannot directly buy property in India. So there are restrictions to that as well. So for a company, if they buy a company which owns the asset is in the name of the Indian company, that is fine. But for them to directly buy that company, it becomes a problem. So a lot of times while structuring the asset purchase agreements or business transfer agreements, those are also things which are taken into account, right? Then what the other thing is the income tax aspects to fit. What are the income tax aspects and how are those income tax aspects done, etc., etc. Those we need to look at. So so I think that is what we'll broadly discuss. We will go through each and every law to see what all is that you require to know from a practical perspective in all those laws and what are the prominent sections that you need to look at. So we will reconvene after this for session number 2 at 1:30. But before that, again, if there are any questions which you have. Yes, Tanvi. And Mohit.
Yes, sir. My question is like when we talk as a lawyer, so one of the main aspect is identifying the liabilities of the company.
Correct.
And that is basically where I think we comes more into picture. But that is also one of the most difficult aspect.
Correct.
Because there can be some past liabilities and there might be some future liabilities which might be coming.
Correct.
So what is the, because we cannot depend on the disclosure of the company because they might be hiding. So what is the best way to implement it and execute to identify all the past and the future liabilities?
Yeah, perfect. So that is why we do a due diligence. Now, how we'll do a due diligence is that as we will firstly send you, if you're the company, we will send you a checklist. That checklist will, in which I'll be asking you a bunch of questions in relation to a lot of these compliances which you do under law. Now you can tell me that, listen, I've been paying my dues under the Labor Act properly for the past 5 years. There is no non-compliance. Now I can obviously not take your word for it. Obviously you're a very reputed man, but I would still like to do my own due diligence. So then what will happen is that we'll say, very good. Can you give us evidence of payment of these under these labor laws for the past 3 years or past 4 years, just for us to see. Then when you give them me your details of these are the payments that you've made, I will see that your company today has 100 employees and your company has had these 100 employees for the past 3 years. But you've only been paying your labor law fees and your all these legislations, the money you've only been paying for 70 employees. So then it's a non-compliance because you're not paying for those 30 employees. Or I ask you that, Acha, listen, what all are the labor laws that you are following? And you give me a list of these 10 laws, which you say that these 10 laws I'm following A to Z everything. But when I look at your company, the nature of the business that you have more than 100 employees and most of them are workmen, etc., etc. And you have factories also. So I would see that in addition to what you're doing, you also need to follow the Industrial Dispute Act and you also need to follow these other 5 labor law legislations, or you are in a state where there are also required to make any of a labor welfare fund contributions are required to be made. So there is this other 5 other legislations which are there, which according to you, you don't even follow because you did not know about them only. Because I asked you what is there and you did not tell me. So there are 2 ways. So firstly, I asked you what all you're following. If you tell me 10 things and I'm compliant with all of them, then I ask you to give me evidence that you've been paying things or you've been following these or you have registrations under all of these licenses. Secondly is that I've used that to figure out that maybe these are these 5 things which you don't follow at all because you don't know about them as well. So those are non-compliances upfront. Then what I do is that I try and look at the minutes of your board. So your board has meetings, your shareholder has meetings. I will look at your board and shareholder meetings to see if there is any matter which was discussed in those minutes, which is something, of concern, which I would want to delve into more. What happens is that every company, private or public, is required to file its audited financial statements with the government. So the MCA every year. So it's around this time every year that every company is required to file its audited financial statements, in which there is a specific auditor, a chartered accountant, who comes and audits your finances and makes a financial report. I will look at that report to see if everything, has the auditor made any comment on any non-compliances in the company or any contingent liability for any labor litigation which is there against you. Right. So I will look into that. Then I will ask further questions based on that. I will then, what I'll do is that we will do a litigation check, because mostly everything is online. You can do a party check and everything online just to make sure to figure out whether or not there is any ongoing litigation against your company. So different ways and different aspects of law which you're required to follow. If your company is in a particular line of business, now obviously we as lawyers know that if you're running a particular type of business, there is a laundry list of 15 licenses and 15 permissions which you require in order to run that business. Now I will ask you copies of those registrations and licenses. It's not enough for you to tell me that, listen, I have everything, you don't need anything. We will ask you copies of those licenses and registrations, and we will see if those are valid and subsisting. Obviously, in all of this, you will have to rely a certain amount on the information which is being provided by the company. If somebody is not doing that, then that is fraud. If they're manufacturing things and they're sending me, false documents, then that is fraud. And then for fraud, there is no bar. I can actually sue you if it's something you're trying to, fraud. If you're pulling a fraud or misrepresentation, you can rescind it. But ideally, yes. So as our part as lawyers, we dig into it that we know that what are the compliances the company is required to make. And then we not only take the word of the opposite party on that, we actually ask them to provide evidence that they've complied with everything, that they've made those payments, that they've been complying and they've been making those filings on an annual basis. Because see, under a lot of laws, you're required to make annual filings, you're required to make annual filings, you're required to make quarterly filings for a lot of things. So whether or not you've done that or not, and those are easy to figure out. Right? So that's how you'll actually dig into doing the historic liabilities.
So we have 3 questions in the chat box. If you could have a look, otherwise I could speak out them for.
First is Shabazz has, my question is related to the type of M&A discussed. Does hostile takeover fall under any category discussed, or terms like hostile takeover informally used in the market? So hostile takeover, what happens is mostly that happens in the US market. In the US, this term you would have heard a lot, that a hostile takeover is taking place. In India, like I said, a takeover will happen, and it's mostly in relation to a listed company. In India, what will happen is that you will have that takeover code, which we'll discuss in detail once we are discussing the laws which are required in a public M&A. And that will tell you what are the safeguards which are there under Indian law which prevent a hostile takeover. So under Indian law, what will happen is that you will have to make an open offer, and everybody has to accept that open offer. You cannot just go, randomly and buy out the entire shares of a company. If you are buying, the moment you're reaching more than 10% of the shares of the company, you have to make an open offer to all the other shareholders. So we have a lot of safeguards in India when it comes to that under the takeover code. So it's not something which can easily happen. So the US market is a different law, securities law, and that's where these things come up mostly. Mohammed has said, see, and in Mindtree, see, in news for hostile takeover in India, it's not that easy to do that. Definitely, it's because I'll tell you when we'll discuss the laws in detail right now. So, would you mind providing an insight on what is the difference between compromise and arrangement as mentioned in section 138, comparing M&A in section 130? See, these are terms. So I'll tell you, in like I said, under this Indian Companies Act, when they made it, so they've made it a very fluid term. Compromise arrangements is something. What if you read the act? I think 230 says that your companies, along with the shareholders and creditors, can enter into any type of compromise or any type of arrangement with each other. So that arrangement can also be, if I'm say, reduction of share capital. That compromise or arrangement with the creditors can be that I'm converting all their money which is owed to those creditors, I'm converting into equity. Or what I'm doing is then I am actually reducing the share capital of the company so that something can happen again between the shareholders. So there is a lot of scope for the shareholders and creditors to come up with a lot of these compromises and arrangements amongst each other to meet the commercial objective. Obviously, all of these compromises and arrangements which are not falling under section 62 or section 42 of the act, those will have to go through a court approved process. And the court approved process will require you to take permission from all the shareholders and creditors, because all of these arrangements that you enter into, or these creative ideas that you have as parties, they will require you to affect the rights of the current shareholders. Say tomorrow, if you want to do a reduction of capital, that today everybody, there are 100 shareholders, all of whom have one share each, but you want to buy back 50% of the shares and reduce the capital only to 50, or extinguish the shares of the remaining 50 people, you will obviously require their consent. So anything other than an amalgamation which is there, any type of compromise that you have, any reduction of capital or any other changes in your share capital that you want to do, if you want to dramatically change the rights of all the shareholders which are there in your company, and a lot of these other things and these other arrangements which you want to come up with, you go through a court process with it, and it's not something that you can just directly do. So anything which is there in section 62 of the Act or section 42 of the Act, fair enough, you go ahead and you do that. But if it's not there in relation to the shares, then you'll have to go through a court-approved process, and for which it's a broad term which you have about compromise and arrangement. These are not defined terms if you see under the Companies Act. The Companies Act has not defined these terms.
Do we have any more questions that need to be asked? Otherwise, we'll proceed for the break. So we have Suresh Babu asking us a question in the chat.
One entity gets 18% stake out of this merger and has 30% employees of the total merger. Then how can they manage in recent mergers of public banks? Again, PSUs are government. Government comes up with a separate act for those PSU mergers, and those are not court approved. PSU, you will see that when the PSUs are coming, budget may they announce that we are planning to merge these 3 PSUs, and then everybody else comes on board. So those are different processes. Insurance companies is not done through your Companies Act. Mostly insurance companies ka the entire merger process and all. Firstly, you need IRDA approval. IRDA has a separate set because it's a regulated industry. So IRDA has a separate set of regulations which are required to be followed. Every person who's buying that company has to be a fit and proper person. You have to meet capitalization requirements which are there, which the IRDA has. You have to have a certain outflow of money, and you have to have certain budgetary requirements for you to, in order to be able to merge those entities. So it's a very different process than a normal company merger that you're having. So if right now it's not as direct. So what we are discussing right now is your plain and simple public company, private company, M&As which are there. Each and every sector, if you start dwelling in, there are many other laws which will come into the picture. Mostly these regulated sectors which are there.
Right. So any other questions? We still have 3 minutes technically, but I suppose if the questions are done with, we can take a break. And I request everyone to reassemble at 1:30 strictly. We'll start on time, and we can take on the further sessions then. Thank you so much for joining in the session 1. So we'll meet you back here at 1:30.
1:30. Thank you, everybody.